The next general defense is right to private defense. So, what is right to private defense? So, it is permissible to use reasonable force to protect one person or the property. So, the essential conditions for this defense, which include the use of reasonable force and the threat for which force is being used, and must be immediate. The force, whichever is said to be done, should be always immediate, and reasonably it has to be foreseeable. So that is, the aggressor must be capable of causing the harm. So it must be necessary to use force, and any immediate help must be unavailable. And to exercise the right to private defense, some prominent case that give useful insights into this defense are Birds versus Holbrook. So in this case, the defendant set up spring guns in his garden without any notice or warning about the same. The plaintiff, who was a trespasser over the defendant's land, got injured and brought up a suit against the defendant. So the defendant pleaded that the traps were set up for the protection of property. But the defense of private defense was not granted by the court. Why? Because it was essential to post a warning or notice, and without either, it seems more probable that the defendant wanted to scare the people rather than protecting his property. So the Consolidated Company versus Curtis, Curtis, Curtis. So 1892. In this case, an auctioneer sold goods believing that they belonged to the seller, but they actually belonged to someone else. And then he was held liable for conversion. So the mistake of fact is no defense. Even though he acted in good faith, the liability still arose. So the next case would be Stanley versus Powell, 1891. A man accidentally shot another while forming at a while firing at a bird. So not liable, and there is no any kind of negligence. So the mere accident without negligence is no liability. But mistake alone is not a defense if the act is unlawful. So like that, we have another subtopic, that is necessity. So necessity, this defense lays down certain conditions where intentional damage to an innocent person is also permissible by law, provided that the action is taken to prevent larger damage. So, Kirk versus Grigori, 1876. In this case, a person dies and his sister in law takes off the jewelry and places it in another room, thinking of it as a safer place. The person's executor sued her for trespass. So the courts held that the sister in law liable because the interference was not reasonably necessary and the defense of necessity was not granted. So, in the same way, we have a statutory authority. If a tort is committed during an act authorized by the legislature or done on its order, then the defense of statutory authority is granted against obvious as well as consequential injury. So, this defense can be asserted against both the obvious injuries which are directly and reasonably foreseeable consequences of the authorized act, and consequential injuries which are indirect or unintended consequences. However, the defenses of statutory authority is not absolute. It may be defeated if the individual exercising the statutory authority exceeds the scope of their authority, acts negligently, or fails to comply with any applicable proceedings or regulations. Furthermore, the defense is not available if the authorized act is inherently dangerous or if it violates a fundamental right. So, Smith versus London and Southwestern Railway Company, 1903. In this case, the plaintiff cottage, which was located about 200 yards away from the railway line, caught fire. He brought up a suit against the railway company for their negligent actions. So it was established that the workers of the railway company left trimmings of grass and hedges near the railway line. So, due to which, when the engine emitted a spark, the material caught fire, and due to strong winds, the fire reached the plaintiff cottage. So, here the court held that the defendant company liable and did not grant the defense of statutory authority. So, the same way, judicial acts done by judges in their judicial capacity are protected. Judges are immune from liability, applies even if the decision is wrong, if done in good faith. So, Anderson versus Gorey, 1895. It is confirmed that judges cannot be held civilly liable for acts done in execution of their judicial duties, even if alleged to be malicious or beyond jurisdiction. So the Anderson versus Gorey remains a cornerstone of doctrine of judicial immunity in common law system. So it reinforced the principle that judges must act without fear of personal liability, ensuring the independence and impartiality of the judiciary. So hence, this is a very important case law here. So the quasi-judicial authority again, the next point is quasi-judicial authority. So the protection extends to persons performing judicial like functions like tribunals, disciplinary bodies, authorities. They must act within their jurisdiction and in good faith. For example, university disciplinary committee decisions, administrative tribunals. The next one is executive authority, acts done by the government officials in the course of duty. The protection is available only if the act is lawful. It is done within the authority conferred by law. So there is no protection for abuse of power. Government officials cannot trespass on the private property without lawful authority. And we have a case, Entick versus Carrington. The case arose when agents of the Secretary of State acting under general warrant broke into a home of John Entick. So, a writer suspected of publishing seditious material. So, Entick sued Nathan, Carrington, and the other officers for trespass. Government argued that they acted under a royal authority, while Entick claimed that the warrant had no legal basis. So Lord Camden ruled in favor of Entick, declaring the warrant illegal because no statute or precedent authorized such intrusions. So he emphasized that what is not permitted by law is forbidden, affirming that executive powers is subordinate to the laws. So always the law is said to be supreme. and whatever the executives, whatever the power they have, everything is said to be the subordinate to law. So the parental and quasi-parental authority. So parents and guardians can use reasonable force to discipline the children. So this authority includes parents and teachers. So the parents are said to be always the parental authority. They have the parental authority. The teachers, they are like the parents, so they are said to be the quasi-parental authorities. So the force must be always moderate and reasonable. Or versus Hopley, 1860. So the decision confirmed that while a parent or schoolmaster could administer moderate corrections, excessive punishment causing death constituted manslaughter. So the defendant, Thomas Copley, taught at a school in Eastbourne, believing a pupil to be obstinate. He wrote to the boy's father seeking consent to subdue the child's behavior through a severe punishment. So after receiving a written consent, Copley beat the child with a thick stick and rope for over 2 hours on 21st April 1859. After this, the boy died overnight from exhaustion and internal bleeding. So the judgment and the legal principle, Chief Justice Sir Alexander Cockburn instructed the jury that English law permitted moderate and reasonable corporal punishment by a parent or a delegated authority such as schoolmaster. So the punishment become unlawful if it was administered in passion or anger. It was excessive in degree or duration. It was inflicted using an instrument dangerous to life or limb. So the jury found Copley guilty of manslaughter because the punishment exceeded the lawful correction. So exercise of common rights is the next point. A person exercising a lawful right is not liable even if harm results. So the principle, a person may use his property as he wishes, provided he acts within the limits of the law. A lawful act does not become actionable merely because it is done with a bad motive. So the Bradford Corporation versus Pickles, 1895. So it is established that the lawful act does not become unlawful. So just merely because it is motivated by malice, forming a key precedent in property and as well as the nuisance law. So the Bradford Corporation operated a public water supply, drew underground water passing beneath under the defendant's Pickles land. So the Pickles deliberately interfered with the flow by sinking shafts and diverting the water in order to pressure the corporation into purchasing its land at an inflated price. So Bradford Corporation sued, alleging that the interference was like malicious and wrongful. So the House of Lords held that the Pickles was not liable. His motive, however, malicious, was irrelevant because he was exercising his lawful rights over his own property. So the law recognizes no cause of action for an act that is otherwise lawful. Merely it is done with ill will or an intention to cause the harm. So the next point is said to be act causing slight harm. De minimis rule. The law does not concern itself with trivial matters. de minimis non curat lex. The law does not take account of trifles. So Ashby versus White. So this case discusses the limits of the de minimis rule and establishes that where a legal right is violated, even if actual damage is slight or absent, an action may still lie. So this is all about the defenses which we have discussed. So you need two general defenses.